Yeah, well, thanks, Carlos. Hi, everyone. Our presentation is, as you can see, on the constitutional balance of in the EU after the euro crisis. So we'll look at how the political response on the euro crisis has affected the constitutional balance in the EU and whether or not that is a problem or not, essentially. So our argument basically takes place in three steps. First, I'll elaborate on what this constitutional balance means and give it a bit more theoretical and normative grounding as to sort of give a more substantial critique into why it might be problematic that we change it through the response to the euro crisis. Then we'll break down this idea of constitutional balance in three different elements. We'll have the substantive aspect, the institutional one, and a more spatial aspect. And we'll go through each of these three, both highlighting what we mean by it, and then emphasizing how it has changed due to the political response in the euro crisis. And then we'll come to our conclusion, which basically will say that this change to the constitutional settlement post-crisis is not only problematic because it's, as we've discussed, it creates legal problems, but also because it increasingly challenges more fundamental aspects of the European Union, including its stability. So, what is this idea of constitutional balance? Now, in reading up on people using this idea of balance in the European Union, many people see it as a functional thing, so as a separation of institutional powers or actors in order for the Union to achieve a certain purpose. So it's very functional. So if we want to achieve peace and prosperity, if we want to fight the debt crisis, we need this constitutional settlement. That's very much the idea that many people have when you think about the balance in the EU. Now, our idea of constitutional balance is a bit more a bit deeper. So our idea is that, like in any polity, the EU's stability is very much contingent on its capacity to actually do what its citizens want it to do. So any polity, including the EU, is an artifact. It doesn't serve any divine good or any greater good. It simply serves as a framework to facilitate the attainment of what the individuals want. And in the EU's context, the individuals and the member states want. So any polity is based on, very fundamentally, on the inclusion of two different things. One is individual self-determination, so the idea that everyone is free and equal. Everyone will have a different idea of what it means, what justice means, or what the good means. And constitutional settlements and democracies protect that individual capacity to just make up your own minds. This is what I think we should do about this. This is my opinion on justice. And on the other side, there's also a political component to that. Because if we want to do things collectively in a polity, or if we want to come to collective solutions, if we want to have a system of healthcare or defense or a monetary policy, we need to find a mechanism that can mediate between all these different ideas of what is just, mediate between them, and actually come to one communal outcome. So this is what we all together think we should do as a community. Maybe it's not my personal opinion, but as a collectivity, this is what we think should be the way we structure our society in normative terms. So these two concepts are very fundamental to any polity, and it's very basic theoretical model, essentially. Now, the nation state, of course, is very good at this. The nation state is completely structured around this. The political system, the separation of powers, if you will, is very much based on this idea that everyone is in here together. There's a very thick political culture, there's grassroots movement, there's NGOs, there's media, there's a very thick public sphere. So the political entities are made very sensitive to know and feel what the citizens actually want. So there's very, very basic elementary logic here. At the same time, the nation state is also very good at actually making sure that everyone's voice is heard, and also that the outvoted people nevertheless agree the outcome. So there's very strong sort of center-periphery relationships, and the idea that you're outvoted in a national context is much less problematic, we think, than being outvoted in a European context. Now, if this is what we think about the institutional settlement of individual and political self-determination, it's very clear that the European Union cannot do this. If you look at the Bundesverfassungsgericht decision in Lisbon, it goes on for about 80 paragraphs about all the deficiencies of the democratic process in the EU. At the same time, though, it's not necessary for the EU to do this. The EU can, to put it very bluntly, they can piggyback on the capacity of the member states to do this. They can piggyback on the capacity of the member states to feel what their citizens want and to articulate that in political terms. It does, however, entail that the European Union can only do a set number of things, so those not requiring direct individual voice. And it also implies that there's a certain way in which the European Union does these things. So it imposes certain limitations. If the EU wants to buy into these things of individual and political self-determination, it structures its capacities in a certain way. So how has it done so? So we argue that this need for political and individual self-determination has been translated in a sort of different way in the EU's institutional settlement, constitutional settlement. And it's much more implicitly done. So the two things we've come up with is, first of all, a commitment to pluralism. So because the EU is not very sensitive to what people want and can't directly legitimize taking one side over another side, its institutional settlement is it creates a supermajority, if you will. It takes up as many different interests as it possibly can. So if you look at the legislative process, you have stakeholders at the Commission side, you have NGOs that are consulted, you have national parliaments that are listened to, you have the QMV or unanimity in the Council, you have majority in the Parliament. So this really creates a supermajority for political decisions in the EU, really making sure that it captures as much of these different interests as it possibly can. Similarly, the idea is that sort of you can outvote minorities, you can challenge decisions for the courts, you have ideas of transparency, very much based on making sure that individuals, regardless of their individual predisposition and normative outlook, can engage with the European Union and feel represented in a way. So pluralism is the first of these ways in which the EU has tried to incorporate self-determination. The second is sovereignty. So if we take this conceptual framework, there's some things that the European Union cannot do. There's some things that are too normatively divisive, abortion, or have too strong a distributive impact, direct taxation. These kind of things have to be directly legitimized by the people. There has to be a direct link between the people, their normative outlook in life, and the eventual decision, because otherwise outvoted minorities will not feel they were represented in the process. So the way the EU has structured this is basically said, we won't touch this. It's a way for the European Union to protect its own supremacy, if you will, its own legitimacy, by saying these are the areas in which we will not venture because we cannot guarantee that we'll incorporate the individuals and communal political decisions in this. So if you look at the treaty systems, you have veto rights in for certain areas, you have a strict notion of competences, and all these things, unanimity, all these things are meant to ring-fence the EU's policies and the EU's influence from these very salient issues such as distributive justice. Okay, so how does the EU actually realize these commitments to self-determination? Now, we'll break down this idea of balance. And I mean, the constitutional aspect, of course, is that not only is it constitutional in the sense that it's enshrined in a treaty in many different areas and through many different ways, but also because it's in more abstract terms, it is constitutive of the Union. It is at the basis of its stability and legitimacy, this idea of the incorporation of individual and political self-determination. So I think for the purpose of analyzing what the Union's response to the crisis has done for this idea of constitutional balance, we've picked up three different dimensions to this balance. So the first is substantive, which I'll discuss, and then Mark will discuss the institutional and spatial aspects of this balance. So, substantive balance, what do we mean by this? So this is essentially what I discussed just before talking about sovereignty a bit. This is the idea implicit from the start in the European Union that the EU does economic policy because this is less salient, there is sort of this idea of sort of Mayone, Pareto efficiency, technocratic expertise. At the same time, member states, because they have this thick political culture, thick political sphere, because they're very sensitive to what people actually want in the more salient aspects of life, such as moral goods, allocative goods, distributive justice. It is nation states that do the social bit. So that was the basic idea. And essentially the idea was that member states doing this social bit would actually legitimize the EU's economic agenda. So you have this economic agenda, and then each of the different member states would normatively embed that, or socially embed that on the national level in accordance to national preferences, so national political preferences. Now, again, this idea of individual and political self-determination in this particular aspect, in substantive balance, was very much guaranteed by just basically saying, EU, you cannot do these social things. These are too distributive, They have too big an impact on the way people live, so we'll have to leave that on a national level. Now, of course, this balance has been unraveling basically from the very start due to these sort of more formal spillovers, substantive spillovers in the Court of Justice case law, and by no means is as separate as I depicted it here. But at the same time, it still remains. If you look at even the political process in the last few years, you had the big fights over the Services Directive, of course, where the argument was very powerfully made that these are things that is so socially distributive that it should be not, the EU should not do this. Or the yellow carding of the Monti II proposal by national parliaments, again on the same rhetoric and same logic of these are the things that we do on the national level because we do them much better. So the logic is still there very much. Now we think that since the euro crisis, this balance has been increasingly destabilized. So I have 1 minute left, so I'll take you through this a bit more quickly, mostly also because many of these elements have been touched on in this panel already and will be, no doubt, developed further. Basically, we've reached a point where the EU thinks it's economically unfeasible not to integrate labor and policy areas. So it simply says, if we want to have fiscal union, if we want to have fiscal discipline, we need to harmonize or at least control labor and welfare areas, which are very distributive and very salient. So on the one hand, it's politically and normatively very unattractive to have the European Union do this because it cannot. On the other hand, it's economically very difficult to let member states do this. So the EU finds itself between a rock and a hard place, but it decidedly went for the economic supervision role. So I'll briefly highlight 3 points. In our paper, we discuss many more. So the first is this co-management of national budgets by the Commission. As Wim discussed, in 21 of the 27 member states, there's a procedure on excessive deficits running at the moment. So what this means is that Commission is basically discharging national budgets. It's giving recommendations, it's giving it green lights. So this quintessential role of national parliaments, the basis of self-determination, national self-determination, is basically giving up to the Commission recommendations. Equally, the hardening of the Europe 2020 provisions, and if you look at the proposals by Barroso or Van Rompuy or Westerwelle on the future of Europe, every single time it says we need to harden Europe 2020. These have to be binding recommendations followed up by the Commission, followed up by the courts. And of course, the most explicit renunciation of this idea of national autonomy in self-determination is the conditionality agreement and memorandum of understanding that debtor states are meant to sign. So in Greece, all trade union agreements were suspended. In Ireland, there was a big push for liberalization of healthcare and labor market reforms. And these are very explicit. And it basically depends on if you want this money, you'll have to do this. So just to round up this a little bit on substantive balance. So whereas at the start it was thought that member states should be left to do the social bits because they're very sensitive to what people want and they give people ownership over the way their life is structured. Now we've gone to completely the other side, whereby the Commission is basically imposing how much pension Greek pensioners should have or whether or not there should be trade union rights in debtor countries. Mark, do you want me to?
Yeah, I think use the, yeah. Yeah, does that works, right? Okay, yeah, thank you also to the organizers for inviting me. As Floris has already mentioned, he's kind of done the hard bit, sort of the theoretical foundations and this complicated framework, and I'm going to be describing the two further balancing categories, the category of institutional balance and a final category, which is the category of spatial balance. Okay, so what about the first one, which is this idea of institutional balance? Well, I'm going to go through this relatively quickly, because of course it's the balancing category that we're most familiar with. It's the only one, for example, that we see represented in the case law of the ECJ. So we very much have an idea here that there should be a balance of power both between the EU institutions, so between the three main political institutions of the EU, but also through the interests that are represented by those institutions. So famously, for example, Nico Maione, in a paper from several years back, talked about different estates that are represented by these institutions. The parliamentary estate that represents citizens, the Commission representing the supranational interest, and the national governments represented by the Council. I also want, though, to relate this to two of the sort of theoretical principles that we started with. So let's think, first of all, about this idea of pluralism. Now, if we think of the most famous sort of instantiation of the institutional balance, which is the community method. Obviously, that's closely related to the ideal of pluralism. What it means is that EU legislation can be passed only if it's the result of some kind of agreed consensus or negotiation between different types of actors. So in that sense, the idea of institutional balance is by its very nature a kind of pluralistic commitment. What we also want to say, though, is that institutional balance is related to the principle of sovereignty as well. Insofar as an idea like institutional balance tries to prohibit the accumulation of power within any one particular institution, it's also a kind of way of translating the national principle of the separation of powers onto the transnational level. And in doing so, also ensuring that the EU level, for example, isn't able to sort of willy-nilly interfere in core state powers or traditional prerogatives of the nation state. So we think there is a close correlation between institutional balance and some of the core normative principles we started with. Now, there are different ways of characterizing how the crisis has changed institutional balance, and there have been some sort of much more nuanced and in-depth presentations on this than we'll be able to provide here. But one of the things that we see is that, in our view, the crisis has seen quite a dramatic shift towards one particular state in particular in the institutional balance and away from another one, which is a move towards the executive branch and a move away from both procedures and institutions that try to represent citizens in policymaking. So let's start with the executive branch first. Well, a lot of people, of course, associate this with the rise of the Commission, and we heard about that in the context of some of the new economic coordination procedures earlier today. What we, though, want to talk about in particular here is the rise of the European Council. So think about different ways in which the European Council has accumulated powers during the crisis. First of all, we see it increasingly acting as an agenda setter. So we know that already, according to the treaties, there's an idea that the European Council is entitled to set strategic guidelines for the EU. But what we see in the course of the crisis is not just the Council setting strategic guidelines, but also the Council creating specific task force, like the Van Rompuy task force, that lay out detailed legislation. So if we think about the six-pack, for example, even the proposals that went through the ordinary community method, they replicated very closely the proposals that were created by the Van Rompuy task force. So we see an increasing prominence of the European Council at the start of the policy-making process. What we also see, though, is an increasing prominence of the European Council later in the policy-making process as well. So traditionally, while it was the prerogative of the Commission, of course, to act as the agenda setter, one of the Commission's other prerogatives, of course, is to monitor compliance with European law, to monitor the enforcement of European law. If you look, though, at the conclusions of European Council meetings, we more and more see the European Council itself taking on this task. So the European Council itself monitoring and commenting on the national budgetary performance either of the Eurozone as a whole or the European Union as a whole or specific member states. So we see a rise of the European Council throughout the legislative process. What that is matched by, of course, is a decline in the influence of the European Parliament in certain concrete ways. So one of these, just to go through it very quickly, is that the European Parliament did not really successfully negotiate for itself, for example, a very prominent role in the context of new economic coordination procedures, like the macroeconomic imbalance procedure, for example. But we also see things like the very tokenistic role the European Parliament is given, or the sort of the need to mention the European Parliament without really giving it any concrete powers in the context of both the Fiscal Compact and the ESM treaties. There is, though, a final way in which we see this sort of citizen branch of the institutional balance being undermined. And that is not simply that institutions that represent citizens are weakened, but also that procedures that somehow represent or protect citizens might be undermined. So one of the important consequences of the crisis that we also see, in fact, this may be a feature of all crises, whether in the transnational context or in the national context, is that we also see a move towards informalization. I want to give one example here, which is the example of the Council. Now, we all know that informalization has always been an important part of the co-decision procedure, for example. But one of the significant elements, for example, of the way in which ECOFIN has acted during the crisis is that we increasingly see its agenda determined in a bilateral way. And in particular, its agenda being determined in very informal settings. For example, the practice of ECOFIN ministers having breakfast meetings, where the ministers of a select number of member states agree on the agenda for ECOFIN later that day. They then agree on how they're going to vote on that agenda, they delegate the vote to junior ministers, and then they go back to their national capitals. So what we see here is not just that the institutional balance might be subverted in some way, but also that there's a kind of sidestepping completely of the institutional balance, a way in which the resolution of policymaking is happening in institutional frameworks that are actually not subject to this balance at all. The final category that we wanted to look at in the paper is the idea of spatial balance. Now, this category is related in a way to the last one, to the category of institutional balance. But whereas that last category was about the balance of power between particular institutions, here we're more talking about the balance of power within institutions. And in particular here we want to focus on the ideal, which of course was very prominent in early discussions of European integration, about finding a balance between the interests of larger member states versus smaller member states, who, if they weren't given certain procedural safeguards in the integration process, might be permanently marginalized in EU policymaking. Now, there are different practical ways in which this has been achieved in the past. So, famously, of course, one of them is that smaller member states tend to be overrepresented. So if we think about the Council, for example, we have an overrepresentation of Malta in relation to Germany and so on. But we also have other things as well. We have, of course, the initiative right of the Commission, the idea that the legislative agenda should not be monopolized by large member states, but should be forwarded by a neutral actor. But we also have other things as well. So, for example, as our chair, Carlos Closa, has talked about, the requirement of unanimity for treaty reform. That's also something that can be seen as a kind of guarantee for smaller member states, a way of ensuring that where there are larger constitutional changes in the Union, those smaller member states have a veto power over how those constitutional arrangements will be changed. So again, relating it back to the principles that we started at the beginning, something like self-determination at the national level is protected by guarding against something like an hegemony of the strong at the European level. How then has this changed? Well, we said that there's a kind of undermining of the other two balances, so of course we think there's an undermining of the third balance too. And the way in which we see that is that the spatial balance is subverted in that new EU institutions or new EU procedures do not replicate some of the procedures designed to safeguard the interests of smaller member states in previous frameworks. So to give one example of that, we mentioned the overrepresentation of smaller member states in the Council. If we look at new institutions like the European Stability Mechanism, perhaps for understandable reasons, in that mechanism we know, of course, that voting is based on capital contributions. What that means, of course, is that most decisions, and many of the decisions of the mechanism's governing board, can be taken even in situations where 12 out of 17 member states of that board object to those decisions. So there's quite a big contrast there as against voting under qualified majority voting in the Council. We also, though, see a change in this final example I mentioned, which is the example of treaty reform. So in previous treaty negotiations, and I want to use the example of Ireland to illustrate this, small member states have often used treaty negotiation, of course, to extract concessions, to ensure that their long-term interests are safeguarded in the way in which the overall architecture of the EU is designed. So famously, of course, when it rejected the Lisbon Treaty, Ireland negotiated a concession whereby it would retain its single European Commissioner. One of the consequences, of course, of the adoption of the Fiscal Compact is that this possibility is more or less removed. As a treaty can be ratified once only 12 member states of the Eurozone approve it, smaller member states are put in a very different position in 2012 than they might have been in 2008. So think, for example, about Ireland's situation in 2012. Whereas in 2008, it's able to sort of negotiate some kind of grand bargain for itself, to negotiate concessions for itself. In 2012, it has a much more stark choice. Either it has to accept the treaty change that's been presented to it, or it has to reject it, but in doing so face not only isolation, but also the knowledge that that treaty will go on ahead anyway without Ireland. It doesn't have the possibility to change the overall treaty architecture. And there is, of course, a final sting in the tail, which is that if Ireland wants access to bailout money, it must ratify the Fiscal Compact. So we not only have a situation where smaller member states are weakened, but also one where poorer member states also might be weakened in the overall institutional architecture. So in that sense, in this category of spatial balance, we feel that smaller states or outlier states might have significantly fewer tools to resist disadvantageous changes to the overall architecture of the Union. Okay, finally, some conclusions. Many, of course, will disagree perhaps with some of the empirical observations made in this paper. And I think sort of listening to the presentations that I've listened to today, I'm even beginning myself to disagree with some of the empirical observations. But hopefully, this is a paper that can provide some kind of analytical framework within which the institutional and normative questions surrounding the response to the crisis can be discussed. I think that we also want to sort of make a normative contribution ourselves. Obviously, some kind of constitutional rebalancing is inevitable following any type of crisis, including the type of crisis that the EU has faced over the last few years. Our view, though, is that the new balance seems to pay very little attention to some of the basic structural and normative principles which have stabilized and legitimized the integration project in the long term. Now, we haven't in this paper, unfortunately, sort of gone beyond that. We haven't yet got to the stage of thinking about, well, how can we build a new constitutional balance for the EU that respects these principles? At the same time, we're of the view that recapturing this idea might require going significantly beyond the purely instrumentalist view of law in public institutions that we've seen over the last 4 years. So thank you very much. I'll stop there, and we're looking forward to your questions and comments.